Hi everyone, I am Chandrika. Through this video, I am going to tell about criminal conspiracy under Indian Penal Code. The Chapter 5A of the Indian Penal Code has introduced into the Criminal Law of India the law of criminal conspiracy. It came into existence by the Criminal Law Act of 1913. It is the only offence where intent does constitute as crime on its own, which is an exception to the general law. Conspiracy is the intention to commit crime or aiding and abetting someone with the same intention to commit a crime. By design, the intention of said law is to curb immoderate power to do mischief. The crime of conspiracy is held to be continued and renewed as to all its members, wherever and whenever any member of the conspiracy acts in furtherance of common design. The main idea of conspiracy is an agreement between two or more parties to commit an offence. Now we will look up to history of criminal conspiracy. The law of conspiracy traces itself back to the English common law, where it started its career as a civil injury but later evolved to be punishable on indictment. In its earliest, the law of conspiracy constituted agreement between parties to carry out an act against the legal proceedings. According to English law, if two or more persons agree together to do something contrary to law or wrongful and harmful towards another person, or to use unlawful means in the carrying out of an object not otherwise unlawful, the person who so agree commit the crime of conspiracy. After the case of Mulcahy vs. R, the IPC was amended in 1870 and Section 120A was added in the IPC. Later on, a whole chapter was introduced in 1913 by the Criminal Law Amendment Act 8 of 1983 with the intent of nipping the commission of crime at its bud. Now we will talk about criminal conspiracy under Indian Penal Code. Section 120A of IPC defines conspiracy. The most important condition of a crime to be considered as conspiracy is an agreement between two or more persons to do an illegal act. If a person is accused of criminal conspiracy, the court must inquire whether two persons are independently pursuing the same ends or they have been conspiring together towards the end. The latter statement renders them as conspirator, but the former does. Some kinds of physical agreement is required to establish two people as conspirator. Now, in the case State vs. Nalini, it was stated that once the object of the conspiracy has been achieved, which may be unlawful, would not make the accused a part of conspiracy. Now, what are the ingredients of a criminal conspiracy? First, an object is accomplished. Second, a plan or scheme embodying means to accomplish an object is present. Third, an agreement or understanding between two or more of the accused persons is present whereby they become definitely committed to cooperate for the accomplishment of the object by the means embodied in the agreement or by any effectual means. Fourth, there is jurisdiction where the statutes require an overt act. Now, what is actus reus? The actus reus in a conspiracy is the agreement to accomplish the illegal act. It is not sufficient that two or more persons are doing an unlawful act at the same time and at the same place. It is important to express the meeting of mind and agree to perform the act. Now we will talk about participation. It is not necessary that all the conspirators are involved in conspiracy from starting to end. Sometimes some other conspirators may leave the conspiracy in between. All of them cannot be treated as conspirators. To execute conspiracy, it is important that the two or more persons are doing an illegal act by illegal means and there is a meeting of mind between all of them. It is not mandatory that all the conspirators are actively participating. Now, Section 34 and Section 120A. The key difference between both is under Section 120A, all the accused will be convicted who were participating in the unlawful act, but under Section 34, read with other offences, under this a single person can be imprisoned as each of them was involved to perform the act. Now Section 107 and 120A. Under this, an agreement is sufficient to commit an offence, but for an offence under Section 107 Clause 2, an act or omission must be taking place in furtherance of an offence. Mere agreement is not enough to accomplish conspiracy. Now we will talk about punishment of conspiracy under Section 120B. First clause is, whoever is a party to a criminal conspiracy to commit an offence punishable with death, imprisonment of life, or rigorous imprisonment for a term of 2 years or upward shall, where no express provisions is made in this code for the punishment of such conspiracy, be punished in the same manner as if he had abated such offences. Second clause. Whoever is a party to criminal conspiracy other than a criminal conspirator to commit an offence punishable as aforesaid. Whoever is a party to a criminal conspiracy other than a criminal conspiracy to commit an offence punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months, or with fine, or with both. Under section 120b, if more than 2 persons are indulged in an offence or to attain the object of the conspiracy, even if some of the accused are released, does not constitute that the remaining could not be held guilty. Section 120 to be read with under section 196 of CRPC. A court cannot take a cognizance of the criminal conspiracy without the prior leave of the central or the state government. Now, here are some criticisms. The law of criminal conspiracy is an old law introduced to end the idea of crime before it becomes an act. But the question arises that is crime really a crime before it is acted upon? It is also to be considered that the law of conspiracy is somewhat arbitrary. If you think about it, if a person plans of a crime alone, it is not conspiracy, hence not a crime. But if the same person plans it with another person, it is suddenly a criminal offense. If we look at the evolution of the law of conspiracy, it is pretty evident that it is an instrument by which the state can essentially detain anyone who try to go against the ideology of the said state. During the independence struggle, you can see that the British Empire used the law of criminal conspiracy to try and shut the struggle down and liberally arrested our freedom fighters. It is usually said about the IPC needs to be reiterated here again. Therefore, it needs to re-examine and re-evaluate itself and catch up with the time and eliminate the irrationality that has crept into Indian laws. Thank you.